Hello, my name is Robert Gluck, and I wanted to talk to you today about product liability claims. I'm a trial lawyer here in Florida, and I've been practicing since 1989, and I have an office in Naples and an office in Plantation, and I handle cases all over the state of Florida. So, products liability, that's an area of the law that describes bringing a claim for a defect or an injury that is caused by a product. That could be any kind of product, from a vehicle to a baby carriage to a razor to a mop to anything that a human being could use, any product that causes them some sort of harm or an injury. So there are certain types of product liability claims. There are three of them. There are claims involving a design defect, there are claims involving a manufacturing defect, and then there are claims involving warnings or labeling. So let's talk about those three just a little bit, and I'll give you an example of what each of those might be. So a design defect claim, that's an allegation that the way that the product is designed is inherently dangerous. That means you're not saying that it was made wrong or that there weren't adequate warnings about how you should use it. You're alleging that just the nature of the product itself is so dangerous that the manufacturer of that product should be held responsible for any injuries that occur. For example, a car that's manufactured that's just top heavy, that automatically rolls over whenever it's hit from the side, is an inherently dangerous product if proven, because you can't warn someone, hey, if you get hit from the side, you're going to roll over. That doesn't solve the problem. You can't do anything to change the design of the product, and it wasn't manufactured wrong. It was made exactly as intended. So if as intended, that vehicle is so dangerous because the way that the engineers designed it made it so top heavy that as soon as it hits, it flips over, then you're alleging that the engineers made a big mistake and this product should have never been on the market. A manufacturing defect of a product is where it's designed properly, and if it was manufactured properly, it wouldn't be a danger to anyone. If a product fails to perform safely because it was made wrong, then that's a different type of a product liability claim. So an example of this is a set of tires may be perfect. They may be designed perfectly, but if while it's being manufactured, there's sawdust that drops down from the ceiling in the plant where the tires are being made, and the sawdust mixes with the glue that makes the tread in the tire, and then the tire falls apart on the road and causes a rollover accident where somebody dies, then there would be a potential product liability claim against the manufacturer, but not in the way it was designed, but in the way it was made. Something went wrong in the manufacturing process. It didn't come out the way it was supposed to. And then if something was designed okay, and it came out the way it was supposed to, but it's got some dangers to it that need adequate warnings, that's the third area, warning or labeling of a defective product. If you have a product that can cause a serious injury, your warnings need to be clear. They need to be in the language of a simple issue is if you're selling a product in a country that everyone speaks English, you need to make sure your instruction manual is in English. If you have a car seat and you're putting in your safety instructions, do not put this car seat in the front seat of a car facing forward. This car seat must be in the back facing properly. But then you have a picture of a car seat on the front seat facing forward on the front box of the product. Then you've got a problem because there's a lot of people that don't read the instructions and they just look at the picture. So your pictures can't be misleading or deceptive. Your instructions need to be clear. Your instructions can't be inconsistent with the photographs that you provide with the instructions. You'd be surprised at how many mistakes manufacturers make. They'll provide a product that can be inserted two different ways. One of them will cause a serious injury to you. The other way won't. Do they have a warning saying, don't do it this way, do it that way? And do they show a diagram of it? So it gets that detailed about these warning labels on products. And the biggest warning label cases there are warning labels on cigarette boxes. It almost seems obvious that we need to warn people that cigarettes cause cancer, but it's a requirement. If you don't warn someone of a dangerous condition, and if you have a product like that, you've got to put a warning on there, and it can't be misleading. And that's how these tobacco companies have gotten in trouble. They've misled people into thinking nicotine was safe many, many, many years ago. And now it's gotten to the point where they actually have to put on their cigarette boxes that cigarettes cause cancer. So product liability claims for anything from drugs that are defective with inadequate warnings to something that you use in your daily life where you get injured, tools are very common. So if you know anyone that's been injured due to a defective product, this is an area where they need a lawyer on board right away to get the right experts and to save and preserve all of the evidence, because these could become a large claim because serious injuries do occur when products are defective. If you see some value here, click the like button below and subscribe to my channel if you want to learn more about my law firm and the other areas of law that I practice. Thank you and have a good day.